We now return to the State Journal's Decision Makers.
And welcome back. We just finished seeing that piece from Brian Ross at ABC News that outlines a judicial problem here in West Virginia, and it goes to the very heart of ethics and the perception of fair justice. Joining us now from San Francisco, Bob Anspach, who is the lead attorney and managing partner of Anspach Law that has offices here in Charleston and Huntington and throughout Ohio. And Bob, welcome to our show.
Thank you very much, Bray. Pleasure to be here.
So Bob, you've seen the report from ABC News. You actually have had a written debate almost with Justice Davis as you have asked her to recuse herself from your case, and she has refused to do that. Can you give us a little bit of what's going on there and what this is about? And I will say before we start, this is not necessarily that somebody's done something wrong. It has to do with the perception of a conflict of interest that in most cases around America, when people reach that point, they recuse themselves from participating in the judicial action.
Bray, I agree with everything that you just said, and in particular the last part. This is about the perception. This is about what a reasonable person would think if he or she were going to go before somebody who was going to decide a dispute that was very important to the parties, because the thing that we're guaranteed under both the U.S. and the West Virginia Constitution is the right to impartiality. Now, that doesn't mean that every time a judge knows somebody, he or she's got to recuse themselves at all. But what it does mean is that under the circumstances here, in my opinion, Justice Davis was obligated by the rules of judicial conduct to recuse or disqualify herself from hearing this case. As you said, since that ABC feature aired, I think in December, quite a bit has happened. In a case that another firm was involved in, where Mike Fuller was representing the plaintiff, and it was against another nursing home, Mark Robinson filed a motion to disqualify, and a couple weeks ago, Justice Davis issued a 29-page opinion dealing with all kinds of legal issues and case law, etc. And in that particular case, she not only refused to disqualify herself because she believed that there was a misrepresentation made by plaintiff's counsel, she even referred him to disciplinary counsel.
And Bob,
we filed a motion.
Bob,
yes,
if I could just interrupt you for a second. And I will say a legal source that's familiar with that case, when they actually did the negotiation, suggested that that information had been known to the parties that were involved in those negotiations. It's likely that that would have resulted in a much lower, tens of millions of dollars. I think there was a compromise that ABC reported of $40 million from a $90 million verdict. Could have been much, much lower, single digits, or it could have gone to the U.S. Supreme Court. And I don't necessarily expect you to comment on that, but that's the kind of that's what this is all about, is the perception of being able to have a free judgment.
That is what it's all about, Bray. That's exactly what it's about. As you're right, I wasn't involved directly in the Douglas case, but what you have said about what the potential result could have been or where the case could have gone if this information had been out there, it could well have been very different from the way it ended up. I say that kind of as an observer from afar.
And
but what we're looking at, go ahead, Bray.
Hasn't the U.S. Supreme Court in the Blankenship Spike Maynard case that went before them, I think 4 or 5 years ago, where they sent everything back and said there was a perception of lack of objectivity by the Supreme Court of West Virginia? I mean, shouldn't that be a guideline to what's going on here?
It sure should. It sure should. That's the landmark case from the U.S. Supreme Court regarding the court and the judge's obligation. And depending on what the ultimate result is in a couple of these cases that are now pending, obviously all options will be weighed. What I don't understand is why go through all of this legal, I'm going to call it mumbo jumbo, all the case law, when it's simply a matter of would a reasonable person think that this is something that should have been disclosed? The answer to that is yes. Was it disclosed? No. Does that mean that a reasonable person might feel that Justice Davis is not the person who ought to decide this case? It doesn't mean she's done anything wrong or illegal, but it's the appearance, and as we see here from the polls that were done, from all the comments to the last article that appeared on the ABC website last week, the vast majority of folks just say she ought to have just taken herself off the case. That's what they say at the very least.
The polls
Some
that
of the
I've
comments
seen,
are stronger.
There are several polls. One is the most favorable to her is 62% of the people are against her. There's some others that close to 90% of the people think that she should recuse herself. Let me ask you this. Your case has not gone before her yet, is that correct?
The only thing that has been decided in our case is she has refused to disqualify herself from hearing the case. The actual decision on the case has not yet been made. And as I said, until that occurs, at that point then, my client will exercise and consider all the options available to it depending on what the result is.
But Mr. Fuller, who is the subject of the ABC Nightline report, is the attorney on the other side of your case, which is the second case where this is at least everybody's aware of it.
Not only is Mr. Fuller the attorney representing the plaintiff, obviously Justice Davis is involved, and it's the same facility, Heartland of Charleston, in my case, as was the defendant in the Douglas case. And the one thing I would like to say about Douglas, when Mr. Fuller's commented on Douglas, he says it was about the facility failing to give this woman a drink of water and she died from that. That's not correct. When this woman came into the facility, she was in her late 80s. She suffered from dementia. She had Parkinson's disease. She had chronic obstructive pulmonary disorder. She was in our facility for 19 days. The family moved her to hospice, and she lived in hospice for another 19 days before her death. And her death certificate says nothing about dehydration, which is what would result from failing to get a drink of water.
All right.
It resulted from dementia and strokes. That's what the death certificate says.
Bob, final question as we're out of time. Do you think it's possible that the Douglas case and or your case could end up before the U.S. Supreme Court if this does not change in terms of how it's being handled?
I have to say that in Douglas, it's probably unlikely because that matter is resolved. As you said, if the information had been available earlier, it might have been a different result. As to my case, I just have to repeat what I said before. Once we get the decision in our case, and we consider that along with Justice Davis's refusal to disqualify herself, my client will consider all options.
All right.
And it wouldn't be the first time that the U.S. Supreme Court had been asked to look at this situation.
All right. Bob Anspach, attorney in Ohio and here in West Virginia, we appreciate you joining us today, and we look forward to talking to you down the road.
Thanks, Bray. My pleasure.
We'll be right back after this.